Good afternoon, everybody, and welcome to today's Open to Export webinar on how exporters can protect intangible assets like IP, copyright, trademarks, and patents in international markets. My name is William Barnes-Graham, and I am the Senior Content Editor at the Institute of Export and International Trade. Next, please. Open to Export is a free online service helping small businesses get ready to sell overseas to our step-by-step articles and guides, regular webinars, our export action plan tool, and our annual competitions. You can find out about all of these on our website at www.opentoexport.com. Next, please. Open to Export is powered by the Institute of Export and International Trade, the UK's professional membership body for traders. Endorsed by the World Trade Organization and the International Chamber of Commerce as a small business champion, we offer a unique range of individual and business membership benefits, education and training catering for beginners through to master's degrees, and an always exciting and prestigious program of events celebrating UK businesses' exporting achievements. Next, please. We will be running a live Q&A later in the session, and you can ask questions at any point using the question box on the control panel to the right-hand side of your screen. We've already been sent a fair few questions ahead of today's webinar, so we cannot guarantee we'll get to everything we receive. The general principle we will adopt is that we'll only ask questions that are relevant to the broader audience, so we won't be able to go into company specifics as such. But if you do have specific questions, we can refer you to our technical helpline afterwards. You can also download a PDF of the slides at any point via the handout drop-down on your control panel, and you will be able to watch a recording of this webinar on opentoexport.com/webinars within a day of it finishing. Next, please. Now, before I hand over to today's speaker, I just wanted to say something about the support we'll be providing during the COVID-19 outbreak. The Institute is continuing to run its training program as normal for now, and with the government indicating that it's looking to still press on with ending the transition period at the end of the year, we do recommend you continue your Brexit preparations, especially as many of our courses are fundable by government grants. We are going to be running a fair few webinars in the coming weeks on the Open to Export platform about what businesses can do to protect their international supply chains from the impact of the outbreak, and we'll be circulating details of those shortly. The Institute offers a range of online support and telephone assistance, which we'll be continuing to run over the next few months. This includes our online customs declarations training, our international trade surgeries, which can be conducted over the phone, the online UK Customs Academy, our technical helpline, and of course our daily bulletins and the articles and guides on Open to Export. You can find more information about our support on export.org.uk. Next, please. For now, though, it's my pleasure to welcome today's speaker, one of our regulars, indeed, in Liz Ward from Virtuoso Legal. Liz has vast experience supporting companies with international IP and is always an extremely knowledgeable webinar speaker. So without further ado, over to you, Liz.
Thank you very much, William, for that great introduction. Could you put my first slide up, please? First of all, I'd like to say what I do want to encourage people to do today is to ask questions, because I do think there's far more to be gained by adding your question and trying to sort out everybody's problems all together. Rather than waiting until after the broadcast. I'm very happy to answer questions after the broadcast too, and you'll have all my contact details. But please, if there's anything that happens whilst we're going through these slides and you want to ask a question, then please type away, let us know early on. The second thing to know is that I've got two co-workers with me today. One of them is Martin, my marketing manager, and the other one is the dog. So I apologise in advance if the postman comes and you can hear him barking in the background. But we're living in some very strange and uncertain times at the moment, and I think that's probably preying on a lot of people's minds today. And I'm going to go into some details in relation to COVID-19 and where we may stand on that. But first of all, let's go through intellectual property and what it means in international trade. Next slide, please. The first topic I'm going to cover are different types of intellectual property, because we find that people often don't really know what it is that they've got, and people will talk about patenting their brand or indeed registering their copyright. So I'm going to deal with some of those issues today, and the first thing I'm going to go through is what the hell is intellectual property, because people are very unaware of it. It's a bit of a Cinderella right, and increasingly it's of national and international importance, because those intellectual property assets that we've got are very much taking over sort of bricks and mortar and tangible assets that people have in a business, such as vans. Now coming to the fore in all the businesses that we see are the brands, the copyright, their website presence, the designs, the text that they've created, and also the patents and the technology. So let's just gallop through some of that. And I'm going to start with copyright, because a lot of people don't really understand copyright. But basically, copyright is the intellectual property right that covers the text on your website, the photographs and the images that you've got, the data that you've created, the artwork that you've created, or the music or the broadcast that you have created. And copyright is ever present and all and amongst us, and it's a hugely valuable right, because if you think about the kind of website text that you've specially created, it could be the reason that your website is performing really well with SEO, or it could be the reason that people buy you rather than another competitor product, because they like the way that you've expressed yourself on your website. So it's a really important right. And it's ever so important now with things like, for example, artificial intelligence and the creation of databases, the creation of things like sets of data for testing material and authorizations. So it's something to be aware of and something to protect according to its importance in your business. The second most common right that we come across are trademarks. Now, trademarks, it could be your brand name, it could be a logo or a slogan, it could be an image, it could be a three-dimensional object. It can even, in certain circumstances, be things like, for example, a Pantone colour or a smell or a shape. So trademarks are fairly broad-ranging, but most people will recognise a trademark because it's the actual sort of brand name that they will associate with. So, for example, Virgin Media or Virgin Airways. It's not necessarily a company name, and there are a lot of misunderstandings that people think if they've registered a company name that they've actually got the trademark and they've got all the rights that they need. That's not the same. A trademark, what it does is basically according to the law, it designates the origin of the brand. So your company could be called anything, but if you've got a very strong brand, then it does deserve to be trademarked. Registered designs. Now, we're seeing more registered designs. It's becoming a more popular right. Registered designs cover the look of something. So say, for example, you have registered or you're innovating in terms of furniture design or things such as photograph frames or car parts, that kind of thing, toys even, can be registered designs. And what a registration does is it gives you a much longer duration than an unregistered right. So say, for example, you design a new toy. In an unregistered design right, you're only going to get a very short period of cover, protection and monopoly to exploit that design right. It varies between 3 and 5 years, depending on where you put it on the market. You have a longer period than that to actually sort of license it for, but your absolute monopoly, as we lawyers say, is only a very short duration. Whereas if you've registered the look of it, you've registered the design, then you have up to 25 years of a monopoly to use that particular look. And as I say, it's increasingly being used by a lot of the creative people within the UK who want to exploit a design on a global basis, because design rights, you can register them in most jurisdictions around the world, and it's a relatively inexpensive thing to do, but it does provide you with some cover for the design and the look of a product. Unregistered designs, well, they cover the embodiment of something. So say, for example, you've designed something that's an ordinary everyday item that perhaps doesn't have any particular eye appeal to it, then it would be covered by an unregistered design. Next slide, please. Patents. Oh, patents are basically, a patent is a registration of a technological innovation. Patents are hugely valuable in modern business because they cover, for example, a new way of doing something, or a new way of creating something, or a manufacturing technique that makes it faster, smarter, less expensive to produce something. These are the kinds of things that are patentable. Some things that aren't patentable, certainly in most of the world, include business methods and software. Some clever patent agents can sometimes get a patent on software because there will be a technical innovation, but generally speaking, things like medical discoveries and business methods and just software algorithms effectively aren't protectable by patent. But they're a very valuable right, and a lot of companies again have gone more into patenting in the UK in the last few years because of the tax advantages of patenting. So you get tax relief, for example, via the patent box, which makes it very attractive because you're only paying corporation tax at 10% rather than the usual 18-20% that you pay corporation tax at. Data, an increasingly important intellectual property right is data. And if you think about it now, a lot of information is sort of accumulated by software and so on. For example, imagine the supermarkets in the current climate, the data that they have on who's buying what and what they need to reorder. I mean, supermarkets have always had very clever supply chains where they look at what they buy and what they sell. But now those supply chains are very sophisticated, and they can tell you precisely how many boxes of strawberries you're going to need the first week in December. That's all thrown out the door, of course, when you get something like COVID-19 in the equation. But in terms of test data, in terms of data over supplies, in terms of data over customers and buying patterns and patterns of behavior, data is becoming increasingly important. And a lot of that is now fed into artificial intelligence and is used to predict disease outcomes, for example, and other really clever uses of data. So if you're a company that collects a lot of data and you use it, then it's of huge commercial importance. Different from data is confidential information. So confidential information, for example, would include a particular recipe or format for doing something. So if you've got a manufacturing technique which is faster, more efficient, it could be covered by confidential information. In fact, it probably would be covered by confidential information. Ways of doing business, if you've got some kind of competitive business advantage, then that could also be covered by confidential information. And confidential information is often overlooked until it's stolen, and then people realize just how enormously valuable confidential information is. One of the side effects I think is going to be over the next few months and years of people working more at home is loss of confidential information. People working on their home computers, people using USBs and so on so that they can carry on working without the rigorous checks that there may be, for example, in an office in relation to confidential designs and data and formulae and things like that. Next slide, please. I still sometimes get businesses who say to me, well, there isn't any intellectual property in my business. And actually nothing could be further from the truth, because all businesses have these intangible assets within their core offering. For example, you might have created a new platform for hosting educational material. Not only have you got intellectual property in the way that the platform is put together, you've also probably got a lot of copyright material in the information that you've put in there. So say, for example, open to export. Open to export will have dozens and dozens, hundreds, thousands possibly, of handouts and information, educational information for people, all of which is very usable and attracts a copyright protection. And that's why I've mentioned underneath about the copyright symbol. One takeaway I'd like you to make from this whole webinar is to start using the copyright symbol on your material. If you are creating test data, for example, or you are creating designs to somebody else's commission, then make sure that your company name or your name is there with a copyright symbol on it. It's very simple to do, but it does designate that it's yours. And in some countries, like for example the USA, the copyright symbol will get you enhanced damages if you've put it on to something. The same applies with putting an R in a circle for your trademark or details of your patent on a patented item. So don't forget, C in a circle for copyright, and if you've got a registered trademark, then it's an R in a circle. You sometimes see people put TM next to something that they're claiming as a brand. TM has got no legal weight to it at all. R in a circle does. And certainly there are provisions within the Trademark Act which will allow you to pursue under criminal provisions somebody who steals your brand and then puts an R in a circle using your brand. That's counterfeiting. All businesses have got data in there. I think increasingly important, people are realizing that data is enormously useful. You know, as I say, things like customer buying patterns, important information that you've gathered from customers and suppliers, it's all there in a business. It's all vitally important. So all businesses have intellectual property, some more than others, some it's more valuable than others. But if you think about it, how would you value it? What would happen to it if you lost it? If you lost your brand, if you lost your trademark, what would happen if you lost all your copyright in your business because somebody else took it? I'm sure your business would be far worse off without those intangible assets. So it's important to acknowledge them. It's important to protect them. And in certain cases, it's important to register them. Next slide. This is my light bulb moment. This just goes to show that, you know, everybody's got an idea in them. We all have creative thoughts. And one thing that's especially interesting about the British as a population is we're very, very creative thinkers. One point I'd like to make here is just how much that creativity and that creative market is actually worth to the UK economy. If you look at the statistics in economic statistics in relation to what the UK produces, our so-called flat white sector of the economy, in other words, all those people who are producing software, producing creative brands, music, broadcast, new ideas for doing things, new ideas for the way that we do business, is actually now worth more to the economy than manufacturing and the utilities put together. It's a huge percentage of our GDP, and I don't think economists have yet woken up to the power of just what a creative nation we are. Next slide, please. One thing that I'm going to talk about today, and I'm really going to labour this point, is about having terms of business. If ever there was a time that I really felt that this is important, it's now. Now is the time that everybody is visiting their terms and conditions of business. For example, we've already had inquiries in relation to customer deposits that people have paid on products. Do they have to be refunded? Because we're living in very strange times, aren't we? Part completed contracts. What happens if a contract is discontinued halfway through? What are your obligations to finish it? Or indeed, what are the obligations of whoever has commissioned it to pay for it? These are really important, and there's never been a better time to revisit your terms and conditions and to have a look at specifically what happens there in relation to your supply of goods. What happens if goods are delayed? What happens if goods are not paid for? What happens if goods are seen to be rushed out or not in compliance with the standards that you normally have? All these sort of situations need covering off in terms of business. So I can't emphasize more how important this is. I mean, just on a personal level, I've been looking at things, for example, refunds on train tickets, refunds or postponing hotel accommodation that I've booked and paid for. I've got an interesting debate going on at the moment with a third party who I booked hotel rooms for, and they're saying it's the hotel's duty to refund me, and the hotel is saying, no, you didn't book with us, you booked with a third party, so it's their obligation to refund you. So even though we're lawyers, we're not immune to these kind of discussions about who's responsible for what. And I know a lot of people who are getting supplies in from China and from overseas. Again, what's the position now with shipping being delayed? What's the position with goods deteriorating en route, or indeed even being impounded in customs altogether? So if your second takeaway from this webinar today is, please look at your terms of business, see what they say, see what your insurance covers, see where you really need to sort of improve those, and revisit the certain terms within there. Again, contracts with suppliers, never been more important now. What happens if your supplier is delivering late or indeed can't deliver at all? These sorts of things need to be set out in a black and white in a contract. Remember that a lot of international contracts are covered by the laws of England and Wales. You may have several people in that contract. I've dealt with one recently for a manufacturer in Indonesia. My client's in Spain, or the company is in Spain, although he also has a UK company. So we've been looking at doing an international supply contract for him to make sure that he's covered by the laws of England and Wales, so that if necessary, he can hold his supplier to account through the courts in London. Creative people. Again, this is a common problem that we see. Creative people who have done something for a company. They may have created photographs, for example, or done designs. They may be a brand agency. It's very important, or created a website. It's very, very important to cover off in those supply contracts the fact that you own all the intangible assets that are produced. So say, for example, you get a brand agency to do you a new logo, make sure that you own it at the end of the day. There's been a very famous case on a few years ago with the Innocent Smoothie. When they started out in business, they got a friend of a friend who ran a branding agency to do their logo, and they never paid him for it. But what they did say is, well, when we make a success of this, we'll give you some shares in Innocent. Well, time went on, this branding agency closed and it became insolvent and was closed down. But sort of 10 years later, when Innocent Smoothies, of course, was taken over, then the brand agency popped up out of the woodwork and said, well, you never paid us for that work, you don't own it. And there then followed a big dispute over the ownership of a very important logo by that stage. Next slide. So, oh, we've gone too far. All companies have a brand. I think it's important to know that everybody's got a brand. Anna, do you want to go back to the last slide? Thanks. Oh, right. Okay, that does seem to. I think that's somebody writing their terms and conditions. Again, it's useful if you are going to write terms and conditions to write a checklist out of heads of terms that you want in those terms and conditions, and filter that down then to your lawyer to do the sort of bespoke drafting. But think about the heads of terms first. Next slide, Anna. So all companies do have a brand, and some are very, very well known. Every year, Forbes produces a list of the world's top 100 most valuable brands. And things like Apple and Google are phenomenally successful brands. And you can put Google or Apple or Virgin, for example, onto lots of different products. You can extend the brand and it still become instantly recognizable. Certainly some companies now make their money from their brand. Stelios, for example, from EasyJet, his company now makes a lot of money from licensing people to use the Easy brand on all kinds of products and services. Next slide. And those are some brands that you may well recognize. The Coca-Cola bottle is quite an interesting one because it isn't just the Coca-Cola bottle that's Coca-Cola as a trademark that's registered. It's the shape of that bottle that's also registered. And companies like Coca-Cola that have got a very distinct product like that will register the shape of their bottle or the shape of their product as a trademark. Bacardi there, a wonderful logo, great brand, instantly recognizable throughout the world, as is Google, a very, very valuable brand, and good old Heinz tomato ketchup. Now, the point about Heinz is that you can put it on any number of products and it's instantly recognizable as being a good product. It's got that brand recognition, that sort of goodwill and everything attached to it that will make people come back and buy more. Even if it's not very wonderful, they'll come back and buy more because they think it's got Heinz and it's got certain sort of kudos attached to it. Next slide, please. I wanted to just talk about copyright here because the one thing that we get more inquiries about, trademarks and copyright, the two key areas that we get dozens and dozens of inquiries about. The photos and texts on website, what we have seen recently, a few years ago, search engine optimization depended on the photos and the text, particularly the text on your website. And then Google changed all the algorithms and that was less important. And if you copied somebody's text, you were penalized for it. We've now seen the reverse of that. The Google algorithm doesn't penalize duplicate text in the same way that it used to. And we're seeing more and more cases of people's website text being slavishly copied and put onto somebody else's website in order to give them an advantage in terms of not just the copyright material that they're using, but the attractiveness in terms of website SEO. Data sets, again, increasingly important, collecting data, artificial intelligence, looking at that data, who's buying what, why are they buying it, what time of year are they buying it, how much are they paying for it, what are your competitors doing. That's all kind of data that's being collated. One of the most exciting areas I see of data collection is actually in the healthcare industry, where collecting mass data sets now means that we've got far better information on things like, for example, drug dosage and who responds better to particular treatments than others. Particularly with cancer treatments and so on now, they're able to map, using these mass data sets, they're able to map the disease far more quickly and predict the outcome, predict the prognosis, predict the rate of recovery and so on, far more accurately than we could ever do so before. And that's all thanks to this mass data that people are collecting. Customer lists. Quite often disappear with staff, unfortunately, do customer lists. I've certainly in my career as a lawyer over the past 25 years, I think of all the things that I see taken and breach of confidence in relation to, it's customer lists, because it's far easier to take your employer's customer list and to piggyback off that than it is to create your own. Know-how. Again, everybody's got a way of doing things. Know-how is increasingly valuable, particularly in manufacturing techniques. Quite often, know-how now is part of something that you'd license, for example, with a patent, because you'd be able to not just give somebody a license of the technology, but also tell them how to use it to the best advantage. Test results. Again, in an increasingly competitive world, where test results are really valuable for product accreditation and for safety testing. Test results, certifications and brochures are hugely valuable sort of intangible assets within a company. And the one point I will make about all of those is make sure you own them. If somebody else has created your photos or somebody else has created your test results, do make sure that at the end of the day, you own them so that you can enforce them. Translations of brochures, again, is another one where we see agents and distributors translating a brochure and then asserting their own rights in that particular translation. Next slide, please. So all those creative things have got enormous value. Please, please, they might not be recognizable on your balance sheet, but please recognize them within the company and give them the appropriate protection that they need. And also record them. Make sure that you've got a written record of who's created what and when it was done. Next slide, please. One thing I'm going to talk about here very briefly is trademarks. Because we see a lot of particularly smaller businesses who go global very quickly indeed. And what happens when they go global is that they often reach markets where they don't have a registered trademark, or they will sign up, say, for example, in Singapore or South America with a particular agent or supplier, and they don't register the trademark. And then the next thing they know is that the local agent has done it. So you need to think long and hard about that, because you can lose your rights in a particular country. It's a first to file system around the world. And if your agent or distributor has registered what's effectively your right in that country, you can lose the right. They can go and then, sell somebody else's product under your brand name. And so you've got all the loss of rights in that country and the loss of reputation, because somebody then decides to take advantage of your good name. So yes, it's a significant investment sometimes. What we quite often help people do is to do it strategically, so that you can get your international rights over a period of time using different international protocols, and that will stretch out the costs and so on of registration. Next slide, please. So the downside to international registration is the cost. And yes, the costs can be very expensive. But the loss of a particular market can be devastating for some companies. A few years ago, I had a client who lost the whole of Southeast Asia for their product because they hadn't registered the trademark in their name. And when they fell out with the local distributor, who was the principal distributor for the whole region of Southeast Asia, they found that they didn't own the trademark, and he then started to use their trademark in that particular location and sell a competitor's products using that brand. So it devastated the whole of the region, and they then had to rebrand and relaunch in the whole area. So that was an enormous cost. Next slide, please. So, global brands like, for example, Nike here, they register in every jurisdiction. I know it's not possible for you to do that, but what I would suggest is that you get professional advice and you register in all the jurisdictions where you really need cover, the key jurisdictions where you're manufacturing and selling or hope to sell within the next 5 years. Next slide, please. So how to keep the costs down, because costs are something that's the elephant in the room, isn't it? Speak to a professional and have a strategy about it. And you need to speak to an expert, because lots of people will say, well, I will file your trademark, but they don't have the requisite expertise in actual fact to look at this from a bigger perspective and to look at your market globally. So they won't necessarily have the contacts to register it internationally. They won't be able to give you advice on how to get it internationally. One of the big elephant traps we see with people who register trademarks either themselves or not using an expert lawyer is they register the wrong specifications, they register the wrong marks, they don't register a word mark when they should do. They'll register a stylized mark. And they'll then have problems with international prosecution because they'll try and get it in different countries. And they simply won't get it through the system because they don't have a locally appointed representative, or because their specification just doesn't meet the local requirements. We're helping quite a big brand at the moment in the USA because the USA Trademark Office has started to audit all the people who have not used a mark within the first 5 years. You have to, in the States, file what's called a proof of use evidence to the Trademark Office to keep your brand alive on the trademark registry. And that's fine for most clients who have used it. But for some clients who've only used it online or only used it in specific circumstances, they're finding that their trademarks are being expunged from the register for non-use. And those are all the sorts of problems that a professional will help you with and give you advance warning so that you're not left in the lurch and caught by the US provisions without at the 5-year mark when you've to produce that information. We often use international protocols as well to register. One of the big advantages of that is that you can spread out the cost over a period of 6 months to sort of 2 years really, using the international protocols, which will mean that you get backdated to the date that you first filed, say for example in the United Kingdom or the EU, but you can then go worldwide with it and stretch out the costs. Do ensure a good clearance search to start with. If you've had proper professional advice, they will do a professional search. This is far, far wider than the sorts of searches you can do yourselves or are done online. The reason for that is, of course, that professionals such as ourselves have really sophisticated search tools that can landscape around a particular mark, so we can see if there's anything on the horizon that's going to cause an issue. And for goodness sake too, remember that you need to register in the right classes. So say, for example, you're a food and drink manufacturer, you may want to just register in the relevant classes, say 31, 32, 30 for your food or your drink. But you may, down the line, want to produce merchandise and so on to go with that food and drink. So, for example, aprons or spoons, that kind of thing. So you might need to think beyond what your immediate use is going to be. You may need a registration in class 25 for clothing, for example. And a professional will put you on the straight and narrow about all those kind of questions. Well, indeed, they ask those questions up front. Next slide, please. Again, collaborating with others. It's a great way to get into a market really quickly, but for goodness sake, make sure you've got a proper agreement in place. Who is your agent going to take orders on behalf of? Are they going to, who's going to keep any kind of product locally? Are they going to shut you out of the market? Make sure that you've got that covered off with really, really good contracts. Ensure again that you've got a proper business plan with your agent or distributor, and that they're not just signing you up because they can, because it's an easy thing to do, and you're only going to form part of what they do. You're not going to be that important to them. Again, make sure that you own all the intellectual property rights. Then, I've heard of companies in China who do nothing but explore whether or not local patent rights have been registered. So you might get a patented product created in China, but then the Chinese manufacturer will file a patent on it. So ensure that you own the intellectual property, and make sure as well you can audit their activity so goods aren't going out through the back door and being made available in markets that you haven't endorsed or approved of. Next slide, please. So what are the main traps in relation to copyright? Well, ownership is the big one. Misuse by third parties is another really important one. Ensure in this online day and age, and we're all online now, make sure that you have a proper contract with anybody who's using your copyright material. A big one that's coming down the line I can see is 3D printing, making sure that your 3D printing files aren't going to be abused by somebody. and monitor it. You do. I'm afraid the price of peace is constant vigilance. So you can use some automated monitoring systems such as Copyscape and so on for websites. But keep an eye out. Make sure that your agents and distributors keep their eye open too for people who are copying. Next slide, please. This is me juggling balls at the moment, trying to keep everything going. I think a lot of you probably on this conference call feel a little bit like that. It is difficult to keep all the balls in the air, and it's difficult to remember everything. But you know what? Good advice is only a phone call away. We don't charge you for sort of 10-minute chat on the phone, and it's better to get it right from the start than it is to not know what you're doing and to then try and pick up the pieces afterwards. Next slide, please. So use international protocols to get covering key countries. International protocols don't just apply to copyright, trademarks. International protocols are involved in patenting. And again, you can use those strategically to stretch out the cost of patenting in a few different countries. International treaties cover things like copyright material and design rights. So again, it's a complicated area, but do make sure that you're aware of these international rights and international protocols. With patents, you do need to get advice early. Please don't do what a lot of people do, which is rush off to sell your product or rush off with your proof of concept to people unless you've got them properly tied up with non-disclosure agreements, and even better if you've already got the toe in the door there with a patent application in. So again, you do need contracts with third parties, particularly if they're involved in the creative process or they're contributing material and so on to your patented your patents and your innovation. Next slide, please. Data. The Cinderella right. Oh, I think we were on to patents. Go on to the next slide, please. Yeah, the Cinderella right, it's called that because it totally is overlooked, is data. But there's two ways of keeping data safe. One is to keep it confidential and to mark it as confidential. If you mark it as confidential and there is a breach of that confidentiality and your data is clearly marked as such, you've got 2 bites at the cherry to restore it to you, because you've got a right under a breach of confidence and you've got a right under copyright. So make sure if you are sharing data with a third party or you're creating design drawings or anything like that, that they've got a copyright notice on and that they've got confidential. Again, you need to think about, in this day and age, it's just so easy to send that email with all that confidential information on to somebody. Make sure that not everybody has access to it. Make sure that if you're sending it to a group of people, that it's only going to be covered and inspected by those who are really kind of need to see it, and that can be covered off in a contract. Because the thing that you need to think about is, what would happen if that data were lost? Would it be a complete loss of an opportunity? And in some cases, that is definitely the case. Next slide, please. Yeah, data is universal. It's absolutely everywhere. It's often totally invisible to you, a bit like this computer code. Next slide, please. Okay, well, I've put my name there, my email and everything, and Virtuoso Legal. We have a lot of resources on our website, but and I apologise for rushing through things today, but I do really want to hear your questions now. Yeah.
Yes. So yeah, thank you, Liz, for the presentation. Lots of useful advice as ever. As Liz mentioned, we are now going to answer some of your questions. Please remember that you can ask questions at any point using the question box on the control panel to the right-hand side of your screen. As noted at the start, we won't be able to get through everything, but we'll do our best, and there's our technical helpline for anything afterwards. Great. So first question we had in was from Law, who's asked, as the European Office patent is not linked to the European Union, why and how could Brexit impact the UK's IP rights?
Well, the European Patent Office isn't linked to the European Union. You are correct. At the moment, you just file one European patent and it's covered by a European treaty. That's how it all works. And it is outside Brexit. So it's going to be, patent rights are largely unaffected by Brexit. My only caveat to that is we don't know what's going to happen with the patent court. Well, we do know what's going to happen to the patent court. It was going to be in London. It's now not going to be in London. And that's somewhat up in the air. Interestingly, in relation to Brexit, because obviously none of that is completely clarified, a lot of the trademark, what we're seeing with this COVID-19 is an awful lot of the trademark and patent offices have started to postpone and delay deadlines for things. And that's had quite an impact on our registration process and also some of the kind of oppositions, revocations and invalidations that we see of trademarks and design rights. At the moment, they're just pushing all the deadlines back. But I think that the whole COVID-19 issue and the impact it's going to have on everybody globally will impact on the Brexit negotiations. I can't see how it would be otherwise.
Yes, we'll have to wait and see, but it would be surprising to say the least. We've had a good question in from Munir, who says, we've recently had an IP breach. We work across the globe, so trademarking in every country isn't feasible. What are your practical solutions for someone like Munir?
Well, you say trademarking isn't feasible. It is possible to trademark globally or right across the globe. It's very expensive, so you have to take a strategic view as to whether or not it's worth it. But the default position on any of that is a contractual one. So if you find that somebody, for example, in, I don't know, Argentina or Brazil is abusing your trademark rights and they're a distributor, then you obviously need to be able to sort of cut them loose and sue them locally. So very often your default position is good contracts if you haven't got a trademark everywhere, so that you can get rid of the people who are damaging your business.
Great. And we've had a question in from Robert, a question we're probably expecting, I think. So he's asked, can the coronavirus be used as a force majeure or act of God to cancel any IP licensing agreements?
The question about that is it depends. Force majeure doesn't normally kick in straight away. Force majeure normally kicks in if there's going to be a long-term problem. So at the moment, it's a little bit difficult to sort of say how much the force majeure provisions will affect any contract, because whilst there are sometimes delays in supply and delivery, for example, they're not necessarily going to be that long term. So without seeing the specifics of a particular scenario, and I'm very happy to discuss them offline if that is an issue for this particular person, I can't say more than that at the moment.
Fair enough. But yeah, we'll be sending a follow-up email after this. So Liz, are we okay to share your contacts or a relevant
Absolutely.
contact? Fantastic. We've had a question from Kevin, who said a company has identified that its website is being copied verbatim and
Oh, yeah.
represented as the copy is. What is the next step?
Sue them. You need to put them on notice, and you need to get them to take it down, and you also need to get them to their internet service provider to take them down, and possibly even blacklist them where they are using that copyright material on platforms such as eBay or Amazon and so on and so forth. Yes, you need to stop that. I don't know why, but all of a sudden we've seen a lot of this recently. People's website text slavishly copied. The difficulty comes where somebody uses similar ideas and so on and so forth, but doesn't slavishly copy. uses their own copyright text. But if it's a line by line copying, then yes, you absolutely need to put them on notice and get them taken down.
Yes, thank you. And a question which sort of follows on. So a question from Andrew's asked, is there any legal recourse towards individuals who dissect and broadcast innovations or products where the item is not able to be patented, but the implementation has had design and efforts applied? Example is given is a product or service reverse engineered and then shared individually via various social media platforms.
Oh, crikey. Well, yes, I mean, it could be all sorts of things. I mean, it could be a breach of confidential information. It could be a breach of copyright. You know, again, without more information, it's difficult to know. Is it something that would ordinarily have been put in the public domain? I guess is my first question. If it wouldn't ordinarily be put in the public domain, and you don't normally put things that have been reverse engineered into the public domain, then there may well be copyright and rights of confidence in that.
Great, thank you, Liz. A couple of kind of quick questions which will hopefully clarify some points in the presentation. Andy's asked, how do we actually claim copyright? Do we simply just add a statement on the material?
Yes, just put a copyright and a C in a circle on any handouts that you do, on packaging, on websites, anywhere where you've got copyright material where it's sort of expressed. Then it needs a copyright in a circle so that you claim your copyright in it. Nothing rests on whether or not you do it. If it ever push comes to shove, and you've got, say, for example, a handout that's yours that you can show you originated back in 2016, and in 2020 somebody's copied it, the fact that you have created that material and you have a digital record of it being created way before the plagiarist has taken it, that would be good enough for the court. But it's always good to put people on notice of the fact that you're claiming a copyright.
Thank you. And a question kind of for a specific industry on that. So Stefan has asked, how can an individual or company copyright music or lyrics?
Well, again, copyright arises as you write the music, and as, for example, if you, with the Beatles, when you record it, because when the Beatles started, they didn't actually write their music down, they simply recorded it. So any kind of a permanent physical expression, copyright arises naturally from that point. There are registration procedures in the States, and if you are a musician, then you are strongly advised, if you want to exploit your copyright material in the States, to register it at the US government has a registry for copyright material, and certainly all the big songwriters over there routinely register all their copyright material there. Over in the UK, over in the rest of the world, you know, certainly in Europe, there is no registry for it.
Okay, that's good to know. And a couple of interesting questions. So Angela is an educational consultant in London. Most of her clients come from the Middle East or North Africa. She's registered in the UK, but would you advise registration in my two core markets, Libya and Saudi Arabia? For example, in case a student or ex-student decided to set up using my name and brand.
I think you'd find enforcement extremely difficult out in both those countries, certainly Libya at the moment, but I think Saudi Arabia may be worthwhile looking at registration. I mean, we don't very often see an awful lot of copying going on out there, but they do have, you know, they do have courts and so on that will enforce intellectual property rights. It's a difficult one. Africa is not somewhere where Africa, the Indian subcontinent, places like that are more difficult. Venezuela, really difficult to enforce your intellectual property rights there. But I think I'd say definitely Saudi.
Okay. And Mark's just asked a question building upon, I think you mentioned China, and he's noting that China has companies that identify your IP and register patents locally. He's asking for a bit of expansion on that, and can they do it after the expiry of the world patent registration deadline for the country?
They can do all sorts, and they do all sorts. One of the one of the things, if you're going to collaborate with somebody out in China, it's worthwhile doing some due diligence on them. Finding out whether or not they've got a reputation for copying and so on and so forth. Do they do it beyond the deadline? They probably do. I've never seen that specifically, but they will just try and register everything. I was rather amused a few years ago when graphene hit the press. Graphene obviously was a new concept, it was an invention that was registered by the University of Manchester. It was kind of a discovery, but it was also an invention. And the University of Manchester filed 6 core patents on graphene. And then in Korea and elsewhere, Korea, China, literally thousands of patents were filed on exactly the same product. Because what happened was all the manufacturers thought, well, you can apply this to, coffee cups, you can apply this to fork handles, you can apply this to, door stops, whatever. And they filed specific patent rights designating all those applications that were already covered in Europe by the University of Manchester patents. But they just took advantage of the local patent office and their ability to patent thousands of different applications. But those patents are only really effective against their own manufacturers out in Southeast Asia. But it's an interesting one. The whole thing of patenting and how worthwhile it is and where you patent is a complicated question.
Thank you, Liz. I know on the doing due diligence on Chinese partners, I know the CBBC are often very helpful in helping companies with that, so they're worth contacting as well in terms of China trade. I'll do a couple more questions as we're starting to get close to the hour mark. We had a question in beforehand from Eduardo, who's asked, he's interested to know more about IP of plant varieties and possible restrictions or specific regulations for trade and use in the UK and EU after Brexit.
Oh, I don't know about after Brexit. There are rights that apply to patent. There are sort of like quasi-patent rights that apply to plant varieties. That's a very niche area of intellectual property law. But if you do come out with a novel plant variety, for example, you've got something that's disease resistant or F1 hybrid that's disease resistant, blah, 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 then it is possible to get some protection of that plant right. And I don't know, but I would suspect that post-Brexit, all those rights will be reciprocally kind of protected within the UK and the European Union. The UK does an awful lot in the world of plant rights, but that's a super niche area.
Yes, yeah, it's an interesting one for sure. And a final question from Dayo, who's asked, in a situation where a product may contain many trademark components, does everyone get patents on the work before the final product is exported, or just one patent license to cover all of it?
Is this for, I guess this is for OEM manufacturing, is it, where you take lots of different components and put them together to make one product? Most people would, most people would separately get patent rights on the individual components. It might be that the manufacturer who commissions it gets a patent on the components all working together. But again, it's very specific as to what kind of product it is that is covered. And, I'd be more than happy to sort of discuss these things offline if people want to do that. But generally speaking, individual components would be the patented ones. And there are specific licensing agreements that certainly, for example, in things like the automotive business, in the automotive trade, you will find that there are patent licenses that cover lots and lots of different components. So say, for example, you've got a headlight that's got 3 or 4 different patented components in and it's put together in the Far East, it's highly likely that those individual components are individually patented and the technological innovation in them is patented, and there are sort of complex license agreements for the manufacturer of the light. So yeah, again, a super niche question.
Well, I think we've run out of questions now, actually. So on that note, I think it's probably time for us to wrap up. Thank you everyone for all the questions. As ever, some interesting things being thrown at us. But yeah, thank you once again, Liz, for the presentation and for the answers.
Thank you, Will, and I'm more than happy to chat offline with everybody who's attended today.
Fantastic, thank you so much. And just a quick reminder as well that you can download a PDF of the slides via the handout drop down in the control panel. So yeah, our next webinar, we're now switching our focus to COVID-19, as mentioned earlier, and we will be running an introductory webinar on what you need to know in terms of the impacts of the virus on international supply chains and global trade next Thursday, the 26th of March. We'll be including details of that in our follow-up messaging, and you can find details at open2export.com/webinars. Next, please. And the Institute is continuing to support businesses through these difficult times through a range of online training and support, and our regular training program is currently continuing to run as well. For those working from home, though, our online support and telephone assistance includes online customs declarations training, helping you to prepare for Brexit, international trade surgeries, which can be conducted over the phone, the online UK Customs Academy, our technical helpline, and of course our daily bulletins and the articles and guides on Open to Export. You can find more information about all of the support on export.org.uk. Next, please. And through these historic times, for many reasons, it's really important that we support each other and share information and wisdom around best practice in global trade and the challenges ahead. Membership with the Institute gives you a support network and wealth of information to ensure that you have everything you need to meet the challenges of global trade. Benefits include access to our technical helpline for questions such as the ones we've answered today, industry recognition of your exporting credentials, a wealth of online information and daily bulletins about all the key trade issues, networking opportunities, and so much more. To find out more about membership with the Institute, please do look at the site export.org.uk/membership, and our membership services team will always be happy to answer any questions you may have. But that's all from us today. We hope you found today's webinar useful, and please do take our exit survey to let us know what you thought. Feel free to get in touch if you have any queries around global trade, and everyone stay safe and speak next week. Thank you. Bye.